So my voice isn't heard in the movie,
Okay.
which was a decision I made because I wanted to focus on everybody and not me. So whenever I ask a question, though I'm generally just going to ask you to tell the story, incorporate my question into your answer so that
Okay.
think sound bites. It needs to stand alone. Whatever you say is a sound bite.
Okay.
All right, let's go back to the beginning. And were you a pastor first or a USA baby first?
I was a pastor first.
All right, so
I began in 1999. I founded a church called All Nations Worship Center. And All Nations Worship Center is located in Elgin, Illinois. We're a small community church. We have about 20 members, so we're a pretty small congregation. We were able to purchase the building that we're in currently. One of my congregation members, Ron Erickson, had been able to started the process of buying a company called USA Baby. And USA Baby is America's #1 specialty retailer of infant and children's furniture and accessories. Had annual sales of approximately $100 million. And so we had about 70 franchises when we had bought the company. And the number of franchises reduced to about 55 due to the long-standing battle between the former owner, Alan Levine, and Ron Erickson. And so that was sort of the beginning point of it. But what ended up happening was Alan had actually hired attorneys Lawrence Kamen, Saunders, and Uhlenhoff, who actually also represented USA Baby. And so there was a clear conflict of interest that was involved in this. He had specifically stated in a non-compete agreement that he wouldn't pursue any of the former vendors, but he continued to use the law firm. But they're part of this overall scheme of corruption. I've alleged that they were involved in a enterprise corruption scheme to bankrupt USA Baby and steal the assets of the company through a fraudulent bankruptcy petition that they filed, or that creditors filed against USA Baby, who they were involved with.
let me stop you for a second and go back because you mentioned a couple of names and I want to make sure I understand. You and who was the other person?
Ron Erickson was the majority shareholder of USA Baby Inc., and Ron was a congregation member.
Okay. And you guys bought it
from Alan Levine in 2004, and we began the process of buying the company in 1999. So Ron was able to, arrange a group of investors in order to be able to do what would essentially be called a management buyout. He had been working for USA Baby first as their director of franchising, then as the vice president of market development. And during his time at USA Baby, he had grown the franchise from approximately 40 units to about 70 units. So most of the growth was based on the work that he had done.
All right, and it was bought when?
It was bought on May 17th of 2004.
But you said something about it started in 99?
The company was founded in 1975. It was founded in Chicago, Illinois. It's a Chicago franchisor under the name The Baby's Room. And The Baby's Room was the Chicago equivalent of USA Baby. It was under the franchisor USA Baby. And USA Baby itself began, I believe, in 1981. And so it had been an established company of about 30 years when we had bought the company in 2004. And so it had, at the time that we bought it, I believe it had about right around $87 million in annual sales. And we had grown the company to about $100 million in sales near the by say late 2006. The average store sales increased from about 1.2 million in sales to 1.76 million in sales by 2008. So the franchisees actually were doing better, but in reality they started to form a coup with the other with Alan Levine, and a lot of it was done within the legal system itself, and attorneys started to come up with this complex scheme in order to, basically bankrupt the company. So there was a law firm down in Texas by the name of Wick Phillips. Now it's Wick Phillips, Gould, and Brant Martin, who was an attorney in the Wick Phillips firm. He was involved with a franchisee, Mike Shaw, and Mike Shaw was the Dallas-Fort Worth franchisee. He had 3 stores. And so what ended up happening was that Mike Shaw, I believe, worked with Alan Levine in order to form this coup within the franchise system. And eventually it didn't just involve these 2 parties, but it involved all of the franchisees. And not only all of the franchisees, but many of the vendors in the industry. Alan he was involved with, he had founded a buying group at the very beginning, which ended up, he ended up forming trade shows. Well, the industry leading trade show was formed by a man by the name of Mike Schaefer's. And Mike Schaefer's was he was the president of a company called Baby's Dream, and Baby's Dream was one of the leading vendors for USA Baby. It was about an $8 to $10 million company, and so Baby's Dream, we were Baby's Dream's number 1 retailer. So we had and Baby's Dream ended up actually right when we had bought the company. The Baby's Room stores at that time had been owned by a franchisee by the name of Craig Nelson. And Craig Nelson had bought the companies from Alan Levine in I believe 2000, right around that time frame. Well, Craig Nelson, who was the owner of the Baby's Room stores in Chicago, ended up going, basically being bankrupted by Alan Levine and Barry Cahotis, who were the majority shareholders of of what was called Baby's Room USA at the time, but it was the franchisor USA Baby. And so there was an assignment for the benefit of the creditors that took place immediately prior to the purchase of USA Baby, the assets of Baby's Room, or the USA Baby franchise system, by Ron Erickson. And I believe this was all done under the cover of darkness in order to try and form this coup even before the sale of the company had taken place. And so later, all of this started coming together. About 2005, I joined USA Baby as the chief financial officer, and I began to oversee the books of the company, began to oversee the payments of the company, and replaced Barry Cahotis as the CFO, and really began to help Ron Erickson, who was a congregation member and a friend. I had known Ron for about 15 years, and he's a man of great integrity. We paid almost all of our bills on time up until the bankrupting of the company by the franchisees. So this was all up and through, so 2005, in January 2005, I had been a consultant for USA Baby prior to that, and I had done consulting work for both the Baby's Room company that was owned by Alan and USA Baby Inc., which was owned by Ron Erickson. And all through this time period prior to 2005, I did consulting work, and the company grew and the franchise system grew. In 2004, after Ron bought the company, what ended up happening is there were a lot of problems that started to emerge and surface, including litigation with the Baby's Room stores in Chicago, which had been bought via an assignment for the benefit of the creditors by Robert Geischiger, and the three leading vendors.
Sorry, hold on. Is that me?
Yeah, that's you. I think it's the lobby. So.
Is it this
Yeah, it was the lobby, I believe.
Yeah, it's Bill Windsor at 214. Did you guys just call me by any chance? You did? If you would, just let, if y'all would do this, if anybody, there's gonna be a bunch of people coming to see me today, just go ahead and send them up to 214. Thank you. Bye. Okay. All right, we're still rolling, by the way.
Oh, okay, great.
Let me go back because I wanna make sure I understand. Were there already problems between the franchisees and the companies when Mr. Erickson arranged the buyout?
There were no problems except for with the babies' room stores in Chicago, and so it was between Alan Levine and Craig Nelson, and basically Alan delivered notices of termination of the franchise agreements to him prior to 2004. And so that began, and so that, I believe that was sort of the kickstart of the plan to really create what I would call get the company back from Ron Erickson after 2004. And so
We just did that.
yeah.
Hello? Please, and today, anyone who comes, just send them on up. Thank you. Different person. So, I can't do that. All right, so the Chicago situation existed, and he was undoubtedly aware of it. He worked for the company.
Yeah, Ron
So that
worked for the company. It wasn't the surprise was that basically the majority majority partners in an LLC that was formed to purchase the babies' room stores in Chicago didn't file. They wouldn't sign a non-compete agreement, which they had originally agreed to sign prior to the assignment of the benefit of the creditors, but that became an issue of dispute. And so we ended up spending about $250,000 litigating that. So, I mean, this was the beginning of sort of the litigation problems that we started to experience. And so after that, Alan brought 6 different litigations against USA Baby. And so the courtroom actually became the battleground for control over the company. I came in 2005 in order to help Ron to prevent Alan from taking over the company through the litigation process, and we were able to stop. I was able to stop a lot of this, through proper fiscal management of the company's monies, and reducing expenses and controlling a lot of the expenditures. And so it really prevented them from doing what they were doing up and through about 2007, when we had a group of arbitration franchisees, is what we would call them. Or what they did is they filed this class arbitration, which was specifically prevented in the franchise agreement. And this was the Wick Phillips firm that had filed this class arbitration. So we fought that in state court, and it's the state court judge stayed the arbitration, but the franchisees began to stop paying royalties at that particular time.
All right. How much did Levine get paid when the buyout took place?
He was paid about $2 million for the company, and so we ended up buying the franchise company for $2.77 million was the total purchase price of the company.
Was there a payout?
There was a $2 million payout to Alan Levine, so we paid him $2 million for the company.
And he got that in cash?
He got that in cash.
All right. And was there another, you said 2.7, was there another?
He had 300, there was $350,000 in assumed debt, and Ron Erickson had $350,000 in phantom stock that he had earned as a result of his work in USA Baby.
Hello.
Hello? Frank Epps.
Hey Frank, come on in.
Sorry, bugging you.
No problem. I told him to try to find you earlier and send you out.
I was sending you pictures and stuff via email.
We're filming, so just
Okay.
have a seat and you can fill this out and this will get us ahead of the game. Just sit anywhere you like. All right, so I just want to make sure Epstein's paid. He gets money.
Levine.
I'm sorry, Levine gets paid.
Yeah.
This is Epstein. And Levine gets paid, so he decides to get paid and try to get the company.
He did. He wanted to get paid and to get the company. And so what you had happen was that, and this was sort of going on behind the scenes. In fact, Ron had hired him as the president of USA Baby. And so he was not only being paid the cash money that he got, but he was also being paid on an ongoing basis where he would be a consultant for the company and he would be an employee of the company. But what ended up happening is he began to sabotage the company from the inside, including by forming and creating problems on the inside of the company, which, slowly over time these things came to light. And so about January of 2005, Barry Cohodes was let go because he was the CFO, and we had trusted him that he would, properly oversee the finances. And I didn't, Ron and I were looking at Ron had brought the finances of the company to me, and I was looking at them, and I was just noticing some irregularities. And so I said, I don't think this is, that he's doing a good job for you. And so that's when I started to join the company. We began to rework the financial statements in order to really begin to understand the financial statements of the company so that everything would be clear and there would be no hidden stuff going on within the financial statements. We wanted everything to be transparent. So, so shortly thereafter, about August of 2005, Ron terminated Alan Levine because of the things that we began to notice within the company that were taking place, including Alan was trying to get USA Baby to stop participating in the ABC trade show, which is there were two trade shows in the baby furniture industry. There was the Juvenile Products Manufacturer Association trade show, and they were very strong prior to 2001. After 2001, All Baby and Child ABC became the #1 trade show in the industry. In fact, they've been featured in different films. What to Do with When You're Expecting is a film that had the ABC show in it. So there's so there were a lot of things that were going on, at that particular time, and so that was sort of what ended up happening, and Ron terminated Alan, and I took over both the CFO role and the Chief Operations role. During the time period that I began to take over as the Chief Operations role, the sales of the individual stores began to increase, and they increased by about $300,000 per store, which is pretty significant for any retail establishment, especially because you don't have any new costs that are coming in place. So the stores began to steadily improve. The problem is that our rebates went down because of behind the scenes things taking place with vendors that we weren't aware of at that particular time, and I've only become aware of recently, where I believe vendors started to delay shipments of products, where they would try to stop the lower the rebate payments. All of these kinds of things were going on, and there was, I believe, a collusion behind the scenes among the vendors and also between Al and Levine. And I believe that he was secretly working with the vendors behind the scenes. You know, I don't have specific evidence of it at this particular time, but I do know that it was discovered that, for example, Babies R Us was involved in a price fixing scheme with Britex and with other manufacturers right around that same time. And so all of this is taking place at the same time, and one of the leading wood vendors, La Joby or Bonavita, that was purchased by a company called Kids Brand, they were involved in customs violations where the president of the company was actually involved in import-export schemes where there were violations of the law and bringing stuff forward. You know, all of this worked to create an environment where there was real possibility for products to not function properly. And so you have to deal that, you understand that you're dealing with babies. And so this is a very significant issue. And so this is one of the things that I'm trying to do is within the industry itself. I believe that there's been much stuff going on behind the scenes. There were very minimal regulations over some of the manufacturers. And so there were a number of, crib deaths that were taking place. And we wanted to ensure that all of our products were safe, and we would provide safety guides to parents in order to help them and do a lot. We were in the process of doing a lot of free stuff. In fact, doing free promos on public service television and trying to create videos to help with safety at this particular time. But, so about 2007, the franchisees there were about 9 of them, collectively banded together to form this class arbitration, which was specifically prevented in the franchise agreement. And that continued, and there was the law firm Wick Phillips continued to promote this class arbitration. It was very expensive from a litigation standpoint, even though I believe it was frivolous claims that they were making, and they didn't have the right to do it in a class form, which is the way that they were seeking to do it. But the franchisees collectively stopped paying royalties, but continued using the name, trademark system, ops manual, everything that we had developed. And so they would continually say that they're having problems paying, things are tough out there, prices were increasing for gas and those kinds of things. And so, I gave them some space and tried to help them to work through payment plans. But what it became clear, and this really became clear after November of 2008, that there was basically a collaborative effort to bankrupt the company through the non-payment of royalties among all the franchisees. And so one of the franchisees, Leslie Roos, who's out of San Diego, California, what she did is she filed an involuntary bankruptcy petition alleging that we owed her money for a debenture payment, which again was specifically subject to arbitration. And so even in going to the bankruptcy court, they didn't have the right to do that, and the bankruptcy judge didn't have the right to oversee this, and this is based on current case precedent that's out there. As a non-attorney, I'm stating that. And so I just, based on my own research and things that I've gone out there to conduct.
Is she the only one who filed, or were there others?
There were
You have to have three.
There were two others that filed. One was a former franchisee and Vice President Wallis, and the other one was a man in this area by the name of Jack Whistler. And so all three of them had debenture agreements, and all of these debenture agreements were subject to arbitration. And so there was really no basis for them to bring this bankruptcy petition into the bankruptcy court, and there was no legal basis for the bankruptcy judge to oversee this bankruptcy case. I think it's water is. So there was no
Noisy room.
Yeah. There's no basis for the bankruptcy judge to oversee the litigation. It was beyond his jurisdiction, I believe. And so you had this going on. The company was in 2008. We had known that this litigation was coming, and we were able to procure a loan from Fifth Third. Fifth Third and American Chartered, and it was about $150,000 line of credit. So from September to November of 2008, the royalties went from $250,000 a month to less than $30,000 a month. And so it became very clear that the franchisees were collectively acting to bankrupt the company. We retained the employees that we had. We had about 17 employees for the franchise company. And so all of this was going on during this time period. We had never missed a payment to our primary lender, which was Commerce Capital. Later, we discovered that Commerce Capital and Alan Levine had been talking behind the scenes. And so they ended up, from my understanding, they ended up reaching an agreement in 2010. But in 2008, about November 2008, we realized that the franchisees were banding together. I began to bring motions before the bankruptcy court personally because we basically were out of money because we had been being strangled by the collective royalty strike of the franchisees. Which I later found out that was a criminal act under Illinois law, at least based on my reading of the law. And so, this was all going on, and about February of 2009, the company was, in December of 2008, there was a Chapter 11 order that was entered where we agreed to enter into bankruptcy. The USA Baby agreed to enter into bankruptcy. In 2009, after that, the franchisees, the ones who had stopped paying, basically brought an action as creditors to have a trustee appointed over the company. So that a trustee was appointed over the company in 2009 on February 4th. The Chapter 11 trustee was appointed on February 4th of 2009. The trustee was a trustee by the name of Barry Chatz. And Barry Chatz was also happened to be the son of James Chatz, who was from a firm Arnstein and Lair, who had represented the Babies Room Chicago stores in litigation against USA Baby. And James Chatz was involved in the negotiations relative to the relative to the settlement agreement that was reached between USA Baby and the Baby's Room Chicago stores. And so, in fact, there were the three vendors actually all signed personal guarantees of this agreement that was entered into, which they had breached afterwards. And so there was pending interest involved with this going on behind the scenes. I raised this before the bankruptcy court, and the bankruptcy judge, Judge Wiedoff, said that there wasn't a conflict of interest. And
there's not a conflict of interest.
There was a major conflict of interest, and with the trustee representing the son of the former attorney for the Baby's Room Chicago stores, who entered into an agreement with USA Baby Inc. Was representing representing USA Baby now as the trustee, which shortly thereafter, I guess, he contacted Alan Levine in order to approach him about buying the company, and out of chapter 7, which he had moved to convert the case from chapter 11 to chapter 7, which I'm in the process of going after him because I believe that there was a conflict of interest. And so I brought this I wanted to sue him. So in order to sue a trustee, you have to receive permission from the bankruptcy court to do it. So I requested permission to sue him. That was denied, of course. Then I brought appealed that to the district court, and the district court judge, Joan H. Lefkow, she basically refused, she didn't even read it. She said, this is not a final appeal, and so I'm not going to listen to it. You didn't ask me for permission to bring this appeal. And so then I appealed her decision to the Seventh Circuit, and that's currently pending. So, all of this has been going on behind the scenes, and I brought probably, I think I brought 5 appeals to the Seventh Circuit and 8 appeals to the district court, and that was used in a published opinion by the Seventh Circuit where they called the stuff that I presented frivolous, and which it was the leading judge, Richard Posner, who created that opinion. And there were 2 other judges that were on that particular opinion. What's interesting to me, one of the statements that they made was that they didn't just say that the stuff that I brought in the pending case that they were listening to was frivolous. They said that everything that I had done had been frivolous. Now, this was a published order, which is precedent. So here you have precedent that's saying that I'm bringing frivolous stuff, including the stuff that I brought before a federal judge, George W. Lindbergh, who had ruled on one of my appeals and had reversed my appeal back to the bankruptcy court because I had sued all of these people, including I think there's a number of judges, state court judges who were involved in law firms and all that for about $500 million. So this is all taking place, and what happened was after the company was bankrupted, shortly about early 2009 through late 2009, a number of the parties brought litigation against me personally and against Ron Erickson personally. And so but they were doing it on the basis of debts that were owed by USA Baby. And so they basically brought these things either under different state statutes or because they claimed that they were personal guarantees or other types of things. But this was all impacting USA Baby and really preventing the really trying to aid and abet, I believe, the people who were trying to bankrupt USA Baby. So they ended up getting state court judges who were involved in 3 different counties, and attorneys brought these actions before these state court judges in 3 different counties, Kane, Cook, and DuPage, which, and this is just a sidebar, out of all the courtrooms that I've been in, DuPage County, which happens to be in the heart of evangelicalism down in Wheaton, right in Wheaton area, is almost like entering into a police state when you enter into the courtroom. There's a police officer with a gun in every courtroom. The judges there, at least what I've found, have been very abusive, probably more so than any of the other courts that I've been in, and including Cook County, which you would think Cook County would be the worst, but DuPage is far, far worse than any of the ones that are out there, at least from my perspective and what I've experienced before them. So,
let me stop you and ask a second. I mean, this is all greed.
It's all greed.
Is there anything other than greed involved here? Is it just simply greed?
There's greed and power and control, and it's I think greed, personal ambition, corruption. I later found out that Judge Weedoff, and this was from a gentleman who had brought a lawsuit against him and the Seventh Circuit, and which actually is now a sealed lawsuit, so you don't even know the names of the parties that are on the they won't even let you see the names of the parties on the case. There's just the case, and you can't even see the names of the parties. But there was a guy who brought a case against Judge Weedoff from a company called McCook Metals, and this was there was a story that was done on it in the Washington Examiner, where they talked about how that this gentleman had brought this case against Judge Weedoff and the Seventh Circuit, where he alleged that one of the leading law firms in Chicago, Seafarth and Shaw, had a $40 million slush fund in where they were using that to bribe judges. Now, I don't know if that's true or not, and I'm not saying that it's true, but it raises my level of suspicion to hear that. Now, it just so happens that the judge, Eugene R. Weedoff, and the law firm are involved in my case, and one of the debenture holders happens to be from Maricopa County, Arizona, which is where Judge Weedoff is supposedly supposed to have a residence there, and somehow there's a connection between Chicago and Arizona. Now, I just so happen to know that one of the leading mob figures in Chicago moved to Arizona. So it's possible, and I don't know this for sure, but it's possible that there's some type of mob connection between all of this. I don't know that, but this is a possibility. But I mean, it is all greed, and that was being done, and really trying to steal the company back from Ron Erickson, who had legitimately bought the company. And what I've seen is I've seen the dark side of the legal system. So all of these people were involved in doing this. What's even more interesting is all of them violated the automatic stay in the bankruptcy court through the actions that they did. So now this is one of the things that I found out as I've been doing my own research, that there is no immunity under bankruptcy law relative to states that violate the automatic stay. So there's no state immunity, there's no sovereign immunity, there's no absolute immunity. And so I've actually incorporated that in complaints that I've brought. And this is well known and well established among the federal court system. And so it's a very interesting thing. So, there's pending litigation on that right now. my goal, number one is I want to see things made right. At this point, USA Baby has been almost destroyed by the actions of these individuals. I think there's about 16, maybe 10 to 16 franchises that are left. In my opinion, somehow all of these guys committed a suicide pact, entered into a suicide pact with one another, drank the Kool-Aid that was being presented to them, and the court system, instead of stopping them from drinking the Kool-Aid, said, just go ahead and continue to drink the Kool-Aid, and why don't Mr. Wallis and Mr. Erickson, why don't you drink the Kool-Aid too? And I said, I'm not going to drink the Kool-Aid. I don't believe in drinking the Kool-Aid. I'm not going to commit suicide on this, and I'm going to continue to fight for what's right. Which to me, one of the greatest rights that we have, at least that I've discovered, and this I do appreciate about our court system, is we have the right to be heard. And I think that most Americans don't realize that we have the right to be heard. The judges are not, they're not gods, they're not gladiators, even though a lot of times judges and attorneys consider themselves to be the gods and gladiators of the courtroom arena. They're servants and stewards. They've been appointed, they've been elected. In certain states, most federal judges have been appointed. And so which out of all of the court battles that I've discovered, I think there's been more integrity and honesty among the federal system than in the state system based on what I've, seen. So, but this all took place so in 2008, USA Baby was bankrupted. In 2009, I was fighting it. I sought to sue in the name and the place of the trustee. I sought to sue the trustee, sought to have exercise rights under the bankruptcy code to conduct examinations of parties, and that was prevented. Did appeals, which that's Bankruptcy Rule 2004 allows you to conduct an examination of anybody involved in bankruptcy in order to see if there's monkey business going on. And so I had wanted to do that, and the bankruptcy judge wouldn't let me do that. So I continued to move forward and continued to, further the case, brought an adversary proceeding in the bankruptcy court in order against about 150 defendants, including the United States, who was involved, in this through, because of everything that happened. And this, I'm sort of getting ahead of myself, but, in 2010, on or around that time, I was contacted by the United States Department of Labor because they were looking into claims by USA Baby employees that we didn't pay them. Well, we couldn't pay them because the franchisee stopped paying us. So here they are bringing a case against me and against Ron Erickson, which is still pending, for not paying the employees, while we are talking to the bankruptcy court about the fact that the franchisees have collectively stopped paying royalties, collectively are using the assets of the company, collectively violating the automatic stay, and collectively bringing state court actions against me and Ron in order to prevent us from doing stuff in the bankruptcy court and handling everything in the bankruptcy court. So in 2010, I brought this adversary proceeding, and it was denied by the bankruptcy court judge, and I brought it to the federal level, which was George Lindbergh, and he was a very decent judge, so I have to give him a lot of kudos for being a good judge.
What was his name again?
George W. Lindbergh, a very good judge, and really treated me very fairly. And so basically what he said is, these are your personal claims. They're not bankruptcy claims, and they shouldn't be brought in the bankruptcy court. I don't know if I agree with him or not from a legal standpoint, but I could respect the fact that he treated me fairly, and so I moved it from the bankruptcy court into the district court, which it's in a case that's currently pending in the district court right now. So he treated me very fairly. And there are good judges that are out there. There are some really bad judges too. And a lot of this began, so in 2010, from 2008 through 2010, I'm trying to proceed in the bankruptcy court, trying to do things through the bankruptcy court, and most of my motions are being denied. I'm not being allowed to present evidence and to bring evidence into the litigation, and I'm being actively prevented from pursuing the claims that I have, even when the claims are legitimate. So, for example, in June of 2008, I brought a motion to sue in the name and the place of the trustee, which is allowed under Seventh Circuit case precedent. So I brought that into the bankruptcy court. On June 2nd, Judge Wiedoff, he denied my motion. Well, on June 3rd, and I said to him, I said, this is did you go through this case precedent? And he said, so on June 3rd, he reversed himself, just by his own act, and he set a trial hearing for June 23rd at 10 a.m. Well, it just so happened that I had another case that was pending that I had brought personally before a federal district court judge, Elaine Bucklow, and she, there was a status hearing scheduled for June 4th, and so she basically struck the status hearing, and she rescheduled the hearing on June 3rd he had sent the order, an email. I had an email sent to me at 3 o'clock stating that he was vacating his order. At 3:44 p.m. on the same day, I found out from Judge Bucklow that she had stricken the court hearing, and she had scheduled the hearing for June 24th at 10 a.m. So here you have, it doesn't take a genius to figure out 2 and 2 that there's communications going on behind the scenes. And so this is all happening, and I'm sort of thinking to myself, this is unusual that this is taking place. So I continue on within the court system, and I continue to move the litigation forward. I think I've had to work somewhere between 12 to 16 hours a day in order to be able to pursue the litigation that I've been involved in at the same time as pastoring the church that I pastor, and at the same time after having everything stolen from me. In other cases when you have something this catastrophic that's brought against you, where it creates such a problem, there's other things that spring up out of that on the side. So, from the church, being involved in litigation before Cook County, or my own self personally being involved in litigation in Kane County, it just created spin-off litigations that, I think at this point I probably have been involved in well over 50 cases of litigation. And I've been doing most of this, most of this pro se. The only case that I had an attorney appointed for me was in federal court, was in a case against Travelers, which I had also, besides owning a portion of USA Baby, I also owned 6 retail stores that we had acquired that were on the verge of bankruptcy when we acquired them. And I began the process of turning those stores around under a company called Midwest Baby Group. Well, in 2006, in November of 2006, we had a major theft that took place in our Aurora, Colorado location, of all places, considering what's just happened in Aurora, Colorado. So we had a major theft that took place in our Aurora, Colorado location. And so we had filed a claim with Travelers for about $1.8 million. Now later I discovered, and this I discovered just recently, that Travelers knew that there was an actual loss that took place. They had actual knowledge that one of the employees admitted to it, to the investigator. They kept that secret from me. And now, and this is what happened. I hired an attorney at that particular time to help us process our claim, and the attorney didn't have me file a proof of loss, which was stated in the contract that you were to have a signed proof of loss. Now, I believe that I faxed it to them, but somehow, they don't have it now. So I don't, somehow they don't have the proof of loss that I sent. And the fax machine that I sent it to, you can actually see the toner on it that's going low. So so it's sort of an interesting thing. So just recently, the judge, who is a decent judge, his name is John Dara, and he's an okay judge, but he ruled based on the current precedent that there needed to be a proof of loss form, that in order for me to get the money that I'm owed, even though Travelers had knowledge of it, Travelers knew it, and they concealed that. So this is the kind of stuff that you see taking place. And I have a court-appointed attorney helping me in that particular litigation. So it's sort of a very, very interesting situation overall, but it's, to see the number of people that have been affected by this and what's been done is well over 500 people across the country who have lost their jobs as a result of it, including in fact, it's probably closer to 1,000 if you count the Chicago area stores. So, what was once a vibrant franchise company, because of the greed of a few individuals trying to take the company back, and because of the lack of accountability of the judges that were involved in this, and because of the legal system, it took a mole of a problem and turned it into a mountain, a molehill of a problem and turned it into a mountain. And I don't think that wasn't by design. I think that that's what attorneys do, is they take small problems and turn them into big problems so that they're able to get paid more money, because it's all about money. And so when you're going into court, what you're doing is you're going into court because it's about money. The court system in some ways has become a temple of greed, and it's a multi-trillion-dollar industry, which I didn't know this when I first began all of this. It is, I believe, either the largest industry in America or the second largest industry in America. And the only competing industry that may be able to effectively compete with it is the derivatives market, which is alleged to be a $50 to $600 trillion industry. But if you look at it just from a practical standpoint, you have all of these judges all across the country that are controlling a lot of money and redistributing wealth from some people to other people, usually from those who don't have money to those who do have money, usually from people, including, and the thing that's happening today, and this is what I've discovered through all of what I've been through, is if you're an unrepresented party and you go into a state court run system, you're more than likely going to be treated unfairly. And you're not going to be able to receive justice before the state court system. I think that there's a better chance for you to receive justice at the federal level based on what I've experienced, because the federal judges are appointed and they don't have ties or as many connections to the legal community. And they're sort of the federal turf versus the state turf. And I don't necessarily think that's a bad thing. So I've had better experience in federal court than I have in state court, but it's been a difficult experience overall. So so in 2010, we brought this litigation against all of these parties. It was dismissed, and the dismissal was affirmed. So I brought it into the district court, which is currently pending. The sad part is not only were the franchisees involved in this by attorneys, but judges were involved in this by attorneys. And attorneys schemed to bring judges into it in order to provide color of law to the decisions that were being made. And this is the kind of thing that you see happening where attorneys will abuse the legal system in order to bring color of law behind the decisions that are being made in order to harm people. And whenever I go into court, this is what I realize, is that there is a gun that is being held against me. Whenever I go into a courtroom, there's a gun that's being held against me. And what I mean by that is that if I don't comply with the order of a judge, there will be a police officer that's going to come. It could be a sheriff or a marshal or some other police officer that's going to require me to abide by that order. So this is done out of coercion. And there is a certain level of state coercion that's understandable. But when you have attorneys for personal agenda who are using the legal system to create coercion against people, it brings significant harm especially if it's all about money, which in this particular case it is. And so that's what I've experienced in the legal system, is you have a system that's it's a big industry involving trillions of dollars, involving many people and many judges who are redistributing wealth from, it used to be just those who were poor. Now it's even up to the upper level middle class. And so there's great redistributions of wealth that are taking place. And this is what I've been involved in, is basically someone was using the litigation mill or litigation industry to steal a company that was purchased lawfully so that they could get for out of selfish ambition. And unfortunately, no one in the legal industry or the judges didn't stand up and say, this isn't right. And one of the things that I've discovered, through all this process, because I've had to do a lot of study of the law in order to be able to understand what's going on, is that it used to be that judges were tied to the Bible and to William Blackstone's legal commentaries. And today, those we're using precedents which are really less than 70 years old, and in most cases it's usually less than 30 to 20 years old, that judges are using to make their decisions. And rather than going by well-established law that had been around earlier, you have that had produced peace and prosperity in our nation. And I call it the two tracks. You have the Bible and William Blackstone's legal commentaries. And when the judges were on those two tracks, they made good decisions. But what's happened is, because they've gotten off track, they've started to make really bad decisions and not equitable decisions. It's okay if somebody has a gripe. It's okay if we have a complaint. It's okay if we bring our complaint into the court system. That's all well and good, but there needs to be honest, honorable men in these robes of justice in order to ensure that people receive justice. And one of the things that's happened is that instead of receiving justice, people are being denied justice, even though the reality of what we're to be experiencing is justice. And so if you look at like in Illinois' Constitution, it says that we're to bring our cases freely, we're to be heard, we're to be, we're allowed to do this. It is something that's a constitutional right under the Illinois Constitution. But, here we are, we're being denied our rights, in many cases being denied the opportunity to be heard. For example, in the first 8 motions that I brought in the bankruptcy court, I think I was heard less than 5 minutes during that particular time period. I mean, how can you receive justice when you're not allowed to bring evidence and when you're not allowed to be heard, when you're actively prevented from being heard, when the motions that you're presenting are summarily being denied, which in most cases, most attorneys will have a briefing schedule that's set where the matter is formally briefed. And in our case, a lot of times decisions are summarily made. And that's not right. And no opportunity is brought to bring evidence, which one of the things in this I wish I would have thought about during the congressional testimony. But if you sue the United States, they get 60 days to respond to a complaint. And which I think if you're a pro se party in federal litigation or in any litigation, you should be given 60 days at minimum to be able to respond. Because we've got to go out there. We don't have access to a lot of the resources that that the attorneys have access to. We don't, in most cases, people aren't able to afford the LexisNexis, type of stuff, in order to be able to do it. So I think that it's important, for people to be able to have sufficient time to be able to respond. And, I'm for a good legal system, but I'm against dishonesty. And one of the things that you don't see is attorneys are not punished for being dishonest, even when it's evident that they've been dishonest. And so how come they're not being held accountable for their dishonesty? And how can they lie? I had one judge, and this was in DuPage County, John Elsner. There was a police officer in the courtroom, who I had a standing, I was presenting my argument before the judge. The police officer during this time period came and stood right next to me. I had an objection that was pending, and he put his hand on me to try and to get me to go sit down. Now this is while something is pending before the court, and then the judge said, Ron Erickson, who happened to be also involved in the case, said this police officer put his hand on Pastor Wallis. And the judge said on the record, he didn't put his hand on him. Now, thankfully, they have video in the courtroom, so it can be seen that he did put his hand on me. But this is while an objection is pending. There's no reasonable basis why he should have been allowed to do that. That's an unlawful, I believe, an unlawful use of authority. It's an abuse of authority. And so no one should go into a courtroom and feel like they're going to be abused by a judge, that they're not going to be heard, that they're not going to be listened to, that we have that right. This is a basic right. This is something that our founding fathers wanted us to have. And I believe that we ought to be allowed to present our side of the case, present our evidence, and to bring the things that support what we're saying into the process. I found that most pro se parties do a better job than attorneys. Most pro se parties actually will go out there and do research on the law to try and understand the law. And in many cases, believe it or not, they present a better factual case than our founding fathers presented in the Declaration of Independence for the Revolution, for the American Revolution. If you go back and you read through the Declaration of Independence and the facts that are in there, there's a lot of conclusions that they state in there that today would be tossed out by most judges, and they would say these are conclusory statements. And so that's the kind of stuff that is happening. And in many cases, people are being denied the right to present their argument because they're not saying it in just the right way. And judges aren't providing equity to people. And this is one of the things that I've learned, I guess, through this process, is that there's two sides to the legal system, what they would call the law side and the equity side. But I believe that, in every case, we're to be receiving equity. That no one should walk away and feel like they've been treated unfairly. And this is what a judge is supposed to do. It is a hard job, but that's what a judge is supposed to do. And what's happening is judges, instead of doing their job, they're doing what is expedient and what's easy. They're getting the money, they're getting the benefits, they're getting the perks, and in many cases they're getting side jobs, being law professors, writing books, doing all of this stuff and getting paid for it, when in reality they're there in order to serve the people, and they're to serve us. They're not to serve themselves of us. And attorneys are to be servants as well. And so the profession of an attorney used to be an honorable profession. And now it's not an honorable profession. And you see all of this that's taking place. And these are the things that I've sort of witnessed and discovered as I've gone through all of my own litigation battles, which are still pending. I don't know how long it's going to take. I'm personally suffering financially as a result of all of this. The church that I pastor is suffering financially. It has prevented me from doing a lot of the things that really matter to me, which improve our society, which is bringing the gospel of the kingdom of God, to our communities, which I want to see. I enjoy writing. I love writing books. My area was I liked writing books about growing in the Christian life, being a godly person, doing things in a good way. And in many ways, I've been sidetracked by all of this. And the only reason that I think that I've been able to survive it is because of, my mom has been extremely supportive. And number two, my congregation has been extremely supportive. And I am grateful, for them stepping forward and being a blessing to me through all of this. But when you're experiencing as much litigation as I've gone through, and being, and by the way, and this is, what I learned, even all the work that I've done, I can't get compensated for it because I'm not an attorney. So none of the time, none of the energy, anything that I've invested in this, I don't get back because I'm not an attorney, and judges won't let me get paid, even if I win. And so the only upside for me is on damages that I get back from the people who did harm to me. And the only reasonable compensation would be punitive damages or other types of compensatory damages. But very rarely do judges issue punitive damages. In addition, so I mean, in some ways, I've been held hostage by the legal system, and this is worse than being held hostage in Iran, being held hostage in America by the judicial system, and in some ways, having your Eighth Amendment constitutional rights violated, where there shouldn't be an excessive punishment, for the things that you're doing, but I'm being punished by me having to spend all this time in order to present my case, in order to get back what's rightfully mine, which was unlawfully taken from me, because the judges that were hired didn't do their jobs and didn't act in a reasonable, responsible manner. And that's not right. And we've got to say that's not right. We've got to say this is wrong. And, we can't have this in our country and see our country survive. How long, if I'm just one person, and this is just me that's happened to me, and it's harmed me, it's harmed those around me. But there are thousands and tens of thousands and hundreds of thousands of people that are having this happen to them. How long can we remain a nation when this is happening, when justice is not being administered by the very system that has been created to administer justice? And if judges and attorneys are not bringing justice into the system, what are they getting paid for? That's what they're getting paid for, to provide justice. The only benefit that they're to be bringing is to provide justice to us. And if they're not bringing that tangible benefit, then there's a problem with that. So that's sort of, I guess, my testimony. And
let me ask you to pick up the book and let's talk about the book a second.
Sure.
So this was prompted by the whole USA Baby story and everything you've gone through?
It has been. I wrote this book in order to detail the corruption that's taking place in our legal system, and it's called Secret Corruption. This is from Senator Mark Solander. He said, "I urge everyone who desires that America returns to its just foundation to purchase this book and let your voice be heard." I say that do not go to court without first reading this book. Reading it could save you big money. Not reading it will cost you more. And so what I talk about in here, and I'll just go through just some of the chapters in order to, the subtitle is The Multi-Trillion-Dollar Business of Litigation in America, How Renegade Judges and Rogue Attorneys Have Corrupted America's Legal System. The book judges and attorneys don't want you to read. And the reason why they don't want you to read it is because of the things that I say in it, which just some of the chapters. In fact, a good friend of mine, he wrote this about it. He says, Scott Wallis is writing an expose on abuses and corruption in the legal system in the tradition of investigative journalists and social reformers such as Ida Tarbell, Woodward and Bernstein, Susan B. Anthony, Rosa Parks, Martin Luther King Jr., and many others. God is the ultimate reformer and is in the Reformation business. He has given us a plumb line and scales as the standard. But some of the titles, I have the introduction where I talk a little bit about my background, but the first chapter is called The Road to Hell. And so I talk about that's the road that we're on currently, that we're on the road to hell right now. Chapter 2 is how the American legal system turned to the dark side, which I believe that we have turned to the dark side, that there is abuse and corruption in our system as there has never been, and it's the greatest redistribution of wealth that the world has ever seen has just taken place, and most people don't even know it. The third chapter is the ascendancy of the judiciary in America. It's sort of interesting because I just saw a cartoon with President Obama in it and the Supreme Court, and in the cartoon they had this where you would hit the where you would have a hammer and you would hit the thing in order for the thing, this little widget or whatever it is go up to hit the bell. And so in the cartoon you see President Obama and he's got a little stick. And then you see the Supreme Court standing right behind him and they've got this great big stick. And so what we all realize is that that the judiciary has a great big stick in America today, and that's not what it's supposed to be. In fact, one of the quotes in here is from William Blackstone, and what he says is and if I can find it, William Blackstone, which I think it's one of the best quotations that I found. Right here it says, if the legislature will positively enact a thing to be done, the judges are not at liberty to reject it, for that were to set the judicial power above that of the legislature, which should be subversive of all government. And so when the judiciary becomes the predominant power in any country, it is subversive of all government. So I talk about in chapter 3 the ascendancy of the judiciary, in chapter 4 the new face of segregation and apartheid in America. Today I believe there is segregation and apartheid in America. And it's not just against the black community today. It used to be that racism was against only those in the black community. But what you have today, and most of the abuse that's happening in the legal system today is happening against the black community. They're being mistreated, and many our prisons are full of men and women, in many cases, who are innocent because of the corruption in our judicial system, and this is plain wrong. And so, here we are, but now it's not just against against those who are of a different color, it's against those who don't have money. And so when you're unrepresented and you go into the legal system, a courtroom, basically what you see over the judge is a sign that says, "Not welcome here. Get out. You don't have the right to say anything." This is what is being presented in many courtrooms across America. And so we're being segregated by our legal system, and in many ways we're serfs if we're not anyone who's not an attorney is a serf. And the attorneys themselves are the only nobles in the court system, and all of the court system is comprised of attorneys, either a judge or an attorney, a lawyer, whether it be prosecutor or a plaintiff lawyer or a defendant lawyer, prosecutor, defense, all lawyers, and it's all segregation and apartheid in America. And then what I talk about in chapter 5 is constitutional due process versus the judicial corruption process. I was going to use something different, but I had a friend of mine saying that was not Christian, and so I had to change that. Chapter 6 is culture of corruption, lawyer shakedowns, scams, and schemes. One of the greatest scams that's taking place, at least what I found, is by immigration attorneys. It used to be that personal injury attorneys were the bottom feeders of the legal system. And you could see that in a movie like Civil Action, where you would have a personal injury attorney, and they were sort of the bottom feeder. And the judge says, "I'm sure you can survive the allegation that's being made by the other side." So they were the bottom feeders. Then it was the bankruptcy attorneys, and they were the bottom feeders. And now you've got the immigration attorneys, And they're the absolute bottom of the bottom. They're the bottom feeders in our legal system. And so you have many immigrants who are going to attorneys who are being ripped off by attorneys, thousands and thousands of dollars trying to get to become legal, and they're not being allowed the opportunity to follow the rules because the attorneys just don't do their job, and they know that they're not going to be punished for it. And then chapter 7 is Judges Gone Wild, how judicial activism is reshaping and redistributing wealth in America. And because judges have gone wild, because our system of justice is so lacking, right now, America itself is being reshaped. And, our society has been changed by all of the corruption that's taken place. I mean, I don't even think that we realize the damage that's been done because there's been so much damage. But, this is a quote that I, have in the book from Daniel Webster, and it's in the chapter right preceding chapter 5, but he says this, and Daniel Webster was he's considered the number one attorney ever in America. He had over 225 cases before the Supreme Court, and he won 50% of those cases that he presented before the Supreme Court. But what he says, hold on, my friends, to the Constitution and to the republic for which it stands. Miracles do not cluster, and what has happened once in 6,000 years may not happen again. Hold on to the Constitution, for if the American Constitution should fail, there will be anarchy throughout the world. And so I think today when you look at our world and you look at America, what you see anarchy around our world. And the reason is because we've not held on to our Constitution. And I believe that as a society, we should be holding on to the Constitution, clinging to it, and additionally, tying down. And in fact, one of the quotes that I have in here is this from Thomas Jefferson, and I love this quote, which I think this is one of the quotes that I really like. All of the quotes in here I think are good quotes. But it's I put this in here in order to right here it says, in questions of power then, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution. And that's from Thomas Jefferson. So we've got to bind down our leaders from abusing their power by the chains of the Constitution. The Constitution isn't just our rights, but they're chains to hold back government and to prevent abuses of government from taking place. And so I'm the reason I'm here is because I want to, one, I've seen this corruption personally. God called me to be a pastor. I've wanted to be a pastor. That's my heart. I love people. And even my enemies, I don't have anything against them. Jesus said forgive. And so I've chosen the path of forgiveness. And one of the things that I say in my book is I say the legal system, that can't heal you. But, through forgiveness we can find healing. And so we've got to understand that the legal system doesn't bring healing for the damage that's been done. That's in a different realm. That's the realm that I deal in, which is in forgiveness and finding forgiveness and helping to find forgiveness for other people. And that's something that I believe we need more of in our day.
Let me stop you and ask you to give me a 30-second elevator summary.
Okay.
You're on the 5th floor, you're going to the 1st floor, you got 30 seconds to tell somebody what your legal situation's about?
My legal situation is about, I owned a company, was involved in a company. It was a big company. It took a lot to get there. I worked hard to be able to get there. I had it stolen from me. I expected to find justice in our legal system. I didn't find justice in our legal system. I expected to be treated fairly. I wasn't treated fairly. And I wasn't treated fairly by the judges or those who were called to oversee the administration of justice. And that to me is the number one thing that that really causes me to be of great concern for our country. Because I believe that if we don't have a place to be able to go and find justice, then I don't know if there is hope for our country. And one of the statements that I put in my book is, if we don't have a legal system that where people can find justice, I believe that in 5 to 7 years there's going to be some form of revolution that will take place. And I'm not calling for that. I don't want that. I love America. I love our country. I'm grateful that God allowed me to be here. But, when you experience the level of corruption that I've experienced and see the number of people that have been hurt by that corruption, it's helped me to understand the plight of those around. And so now I tend to be more suspicious of those who are prosecutors, and I tend to be more suspicious of those who are judges. And I think that that's lessened our legal system in its entirety. And I think that that's a sad day for America. And so I would like to see our country, specifically our legal system, reformed purposefully in the realm especially of judges and attorneys being required to be honest and being held accountable for dishonesty.
All right, and one last question. 30 seconds or less. You're talking to people who don't have a clue that this exists. They doubt people who say that it's corrupt. They figure, you were a poor loser in court or whatever. What do you say to those people to try to get through to them?
If I would have heard my story prior to going through everything I've gone through, it would have been very hard for me to believe that this was possible, that there was as much corruption in our judicial system as there is. But after going through it, what I want everyone to understand is that you're next. It's not just a matter of if it's going to happen, it's a matter of when it's going to happen. Because the number of attorneys that are being churned out by law schools is ever increasing. If you go into your phone book, one of the largest sections in every phone book is that for attorneys. And it's between attorneys and doctors, and I think attorneys have more space in the phone book than doctors. So what I'm saying to those who don't believe this could happen to you is you're next. Eventually you're going to find yourself in trouble. And when you do, you're going to experience the corruption that I've experienced, and it will be, a heart-wrenching thing. This is our current system is a system that creates an opportunity for what I call litigation terrorism. And so we do have a form of terrorism in American courtrooms every day. And that terrorism, we do have a form of litigation terrorism that's taking place in our courtrooms today. It's from those within the legal system. And the attorneys are abusing the legal system to be able to get money from people. Eventually they're going to come after you and I. And they did come after me. And I've fought. Some people don't have the fight in them. Most people don't have the fight in them. I've had some members of my family who've gone through it. If you're not an attorney, and you're being held accountable for the laws that are on the books, and most of the time those laws are hidden, and the case precedents are hidden and not easily ascertained, and you're being held accountable to all of that, it's almost impossible for you to receive justice, especially when the judge himself feels like an attorney is going to do a better job because he is an attorney, and attorneys have to stick together. And that's sort of what the legal system is. It's a fraternity of attorneys, all the attorneys sticking together, all of them slapping one another on the butt when they get off the field and go into the bar room in order to congratulate one another over the money that they've been able to get from you and I.
You're just one big walking soundbite. That's